The first thing you want to do when you hired on a job, I don't care what state you're in the United States, you send an email. Keep a paper trail of everything that you need to prove. You send an email to HR and you ask them to provide you with all the policies and procedures that you need to comply with during your employment. The purpose of this is so you can study it because these documents are very important. Once you do that, you want to study them, not read them, study them. A lot of people right now, they are working and they don't know the policy and procedures that they must follow. Therefore, you don't know when your employer or the manager is deviating and violating your rights by not following these policies and procedures. The number one thing you want to do on the job is never quit. Never walk away from your job. Never. Now, let me tell you and demonstrate how important these documents are. When you're hired on a job, they have guidelines that you must follow. And a lot of jobs set you up to fail when they hire you through the manager because they deliberately fail to train and make known these policies to you. What they'll do, they'll bring papers in front of you, you signing off on them, but you never read them, nor do you have a copy of them. So when you step wrong, they fire you and they say, we gave you notice, and here is a copy of what we gave you. But before I go any further, let me be clear on one thing. And if you are fired, never ever sign any documents. You don't have to. That is a trick that they do. Never ever sign those documents. The reason why they're trying to get you to sign these documents when you're fired, because they want to trap you to where you don't have a valid claim for unemployment nor a lawsuit. A lot of times when you're fired, they say, just coming off, we need you to sign these papers so you can get your check, blah, blah, blah. You don't have to do any of that. That is a ruse. That is a trick. They go, oh, if you don't do this, you won't be able to get on. Hey, walk away, don't sign anything. By the end of this video, you'll understand why you shouldn't sign anything. Once again, never walk away from the job and say, I don't need this job. See, a lot of people do this because they really don't understand unemployment benefits. So in this video, I'm going to show you how to preserve your right to unemployment benefits. Your first order of defense is knowing the policies and the rules that govern you. A lot of people get tripped up on the drug policy. So if you're working now and you're looking at this video, you want to ask HR to send you the rules and regulations on the policies that govern how you should conduct yourself at work. Now, once you study these rules and regulations, let's say one day they want to give you a drug test. In the policy manual, it says drug tests will be conducted at the facility by so-and-so or more persons, and that they will be using a particular drug kit or drug kits along this line, and that the drug test will be carried out via urine sample. They call you in one day. They say, hey, look, we're not doing a urine sample. We're doing a hair sample or a fecal sample. And you said, nah, I'm refusing. I'm not doing that. I'm not doing that. And they say, why? They say, well, that ain't in the policy. I'm not doing that. And they say, well, if you don't do it, we'll fire you. I'm still not doing it. I'm still not doing it. They can say, okay, you're fired. Don't leave and just leave. You file a complaint with the Human Resource Office concerning this incident. Plain and simple. You state the facts. You keep a copy of your complaint. When they call you in the office and say, hey, we need you to sign these papers before you go so you can get your check, that's a trick. Don't sign anything once you're terminated. Don't sign anything. Sign nothing. It's a trick. That is a trick to try to foreclose your right to unemployment benefits. Don't do it. After you file your HR complaint, and I say people be very quick when you file your HR complaint. I don't know what your various state requires you. Either way, I advise everybody to file their complaint within 7 business days or earlier. Keep a copy of your complaint. Depending on what state you also file a complaint with the Texas Workforce Commission or any state you stay in, it could be Wisconsin. But to make it simple, whatever your state requires, you file that complaint with them or equal opportunity, employment opportunity. You file your complaint. Keep a copy of it. State the facts. Because these facts are going to determine whether you get unemployment. Because this is how it works. If you fired and you go try to apply for unemployment, they ask you, why are you unemployed? And you have to tell them. And they want to know where you work. And then they take this information and say, okay, we're going to contact her last employer and say, hey, this person is applying for unemployment benefits. You got a problem with that? That employer is going to look and see if you filed a complaint. Going to look and see what's the reason behind firing you. Let's say in this situation, they said, well, the person refused to take the drug test and he filed a complaint. And they're going to see where you cited the policy, see what you cited. You're going to say that they deviated from policy, so you wasn't obligated to follow that. And they fired you at no fault of yours. That employer will look at that, and the employer have to substantiate the reason for firing by sending those documents to the unemployment people that you're seeking the unemployment for. And they know if they send it, it's going to substantiate your claim. Or if they deny your claim and don't send those documents, you have to understand to be ready to attack that. Because they have to substantiate the reasons with documents. And what they'll do is, once they get these documents, they'll tell you they're going to schedule a hearing. It'll be over the phone sometime. It can probably be Zoom, but more of it's going to be over the phone. You have to be ready to take that phone call and be ready to question your employer. It's like a little mini trial. At this point in the game, people, you are effectively litigating unknown to you. You are really litigating a claim. This is why you need to know the law, because at this point you are litigating at an administrative level. This is why they tell you you can appeal after that, and if need be, go to a court of law, a court of record. This is why you need to know the law. Don't let people tell you you don't need to know the law, because you do. See, at this point, you think, oh, it's just a procedure. No, you are litigating at an administrative level. So you get the phone call. You have a right to question the employee. And so basically you go on and say, okay, let me ask you something, Miss So-and-so. I was fired because I refused to take the drug test, correct? Could you point in the policy where it states I must take a drug test with a fecal sample and a hair sample rather than urine when the policy states urine? You know, it's not going to be there. They can't support what they're saying. And they're going to say, well, it's not there, but we have the discretion. And you say, okay, You said the administrative hearing, I like the record to reflect at this time that the evidence supports that I had no obligation to take the drug test with a fecal sample or her sample. My due process rights were violated. I was not placed on notice that I had to give a fecal or her sample. I was placed on notice of a urine sample. At this point in the game, people, the administrative officer understands that your due process was violated. And say, I rest my case, hearing officer. At the point, your employer knows he or she is out of there, and you will be getting the unemployment benefits. The hearing officer knows. So the hearing officer is going to tell you he's going to render the decision, blah, blah, blah. Let's say you get the decision and they deny it. You better appeal it because you have a ground for due process. The evidence is in your favor. But at this point in the game, a reasonable hearing officer will grant it because your employee did not place you on notice of a fecal in her sample. Therefore, you under no obligation. You are only obligated to comply with the rules and policies that they gave you and put you on notice of. Now you have knowledge on how to preserve your right to unemployment benefits. Because a lot of people don't understand that if you walk away, you don't have nothing coming. Or if you steal, if you are fired for your own fault, you have no unemployment. Don't even apply. Don't even apply. But if it's no fault of yours, you contest it. So there you have it, people. Protect your interests at all times. Learn basic law to protect yourself, because without it, you can be giving up your unemployment benefits.